Bismillahirrahmanirrahim. Welcome to online session on HEC Law GAT. Our first sessions received a tremendous response and numerous people have asked us to hold more sessions. We are holding this session in response to the public demand. My name is Zubair and I head the Global Institute of Law, Oxford. I join you from Oxford and our guest speaker, Oves Anwar, joins us from Islamabad. It is my pleasure to introduce to you Mr. Mohammad Oves Anwar, who is the Director of Research at the Research Society of International Law. He has an excellent career and is a role model for our students to follow. So over to you, Oves.
Thank you very much, Zubair Sahab. First of all, it's a pleasure to be here and to be discussing this important topic. I hope this lecture will help the students who are going to be giving the test, the law GAT, very soon. The topic of today is public international law. It is a very vast subject, but certainly one lecture or two lectures on this will not be able to do justice to the topic. However, I do want to introduce participants or the audience to some of the more basic features and fundamentals of international law, public international law. So just a brief overview of the presentation. I'll be looking at the fundamentals of public international law, and from there I will then go to the sources. And I'm going to devote quite a bit of time to the sources of international law because that really is the basis of any discussion that we can have on international law. Within that, I'll be looking at customs, customary international law, treaty law, general principles, and subsidiary sources. I'll then look at the subjects of international law, and very briefly after that, I'll touch upon some major themes of international law, such as human rights law, international humanitarian law, the use of force, etc. So let's jump straight in. Public versus private international law. Now, before we go into a discussion on what public international law is, we have to differentiate it from private international law. So a very, very basic differentiation is that public international law is primarily a state-to-state entity. It governs the relationship between state A and state B, or between state A and a multiplicity of other states. Private international law, on the other hand, is when, say, a citizen of state A gets into a commercial contract with a citizen of state B. Now, there are international rules which also govern these relationships, and this is what we refer to as private international law or the conflict of laws. For example, when the domestic laws of two different states interact, how are we supposed to deal with that, and how are we supposed to resolve conflicts that arise in that sense? So that's really the definition or the difference between public international law and private international law. So we will be discussing the former, public international law henceforth. Let's go straight into a textbook definition. It's a very, very simple definition. Public international law is the system of rules and principles which governs the relationship between states and other subjects of international law. So essentially, the rules that govern how states interact with each other, whether it's trade, whether it's armed force, whether it's diplomacy, whatever rules exist between states and other subjects of international law. And we'll go into more detail on what subjects of international law are. But in essence, traditionally, public international law has applied just between states, but especially after the Second World War, we've now seen a gradual change, or an expansion of the subjects of international law, which now also include individuals, but also in international institutions, even multinational corporations, and a multitude of other entities, which we'll go into in more detail. Now, to properly understand international law, we have to let's compare it to a domestic legal system, a national legal system. Now, what are some of the common elements of a national legal system? First of all, you have a legislature that makes law, so it's involved in lawmaking. Then you have a judiciary, which is involved in interpretation of law or the determination of law and the application in that sense. And you have an executive, which is involved in the enforcement of that law. So you have the legislature, judiciary, executive, the three arms of the state that function there. And another element which is important to note is that in a national legal system, there is a monopoly on legitimate violence. Only the state is permitted to act to enforce its laws through violence if required. And so that's what we have, common patterns of a national legal system. Let's compare this, and now let's look at this. This is a top-down relationship. So in essence, what we say is that within a state, you have an executive, a legislature, a judiciary that takes decisions for the citizenry, for the people who are subject to the law. And so we see we vote our parliamentarians in, they make laws which then affect us. So it's a top-down relationship there. The executive can enforce the law on us because it applies the laws that are made by the legislature. And the judiciary then gives verdicts that determine, our rights, the scope of our rights, and a number of other things. So it's a vertical relationship, top-down relationship. Now, can we compare this to the international level? At the international plane, at the international level, there's really no real legislature. I mean, you could say that the UN General Assembly passes resolutions, but they don't carry the weight. They're not binding in that sense. We could also say that there's no real international executive who enforces the law. You could have UN bodies and stuff, but they don't enforce all of international law or even parts of international law in a large sense. They have their particular mandates, and they can be stymied by other governments. They can be stopped by other governments. And there's really no international judiciary as we understand in a domestic system judiciary. For example, I've mentioned the International Court of Justice, the International Criminal Court, but the problem with both of these is that their jurisdiction is dependent upon states accepting their jurisdiction. In Pakistan, for example, we can't say that I don't accept the High Court's judgment against me. We don't have that option. It is binding, regardless of whether I agree with it or not. You see? So this is something which is different from the international realm. And from this, you get a number of criticisms that also arise. But we'll just look at a little more about the nature of international law. Now, international law has a horizontal relationship, side-to-side relationship, as opposed to a domestic legal system. So at the international plane, matters are decentralized. They're decentralized to the people who are affected, or the entities, which is essentially the states who are affected by it. So there's no central authority which exists that can impose its will on all states. So the UN, for example, can't force states to do things by itself. It doesn't have a police force. It doesn't have a military force of its own. And secondly, at least theoretically, all states are equal. Now, we know that under international relations, some states are more powerful than others, but at the international level, at the UN General Assembly, for example, all states have one vote. They have a vote at the UN Security Council, but of course, there are changes, there are differences because of how the UN system is developed. So you have the veto powers of certain UN Security Council members. Now, the power to make law is also therefore dispersed amongst the states. The states come together to make laws. In a national situation, we vote our parliamentarians into power, and they make laws essentially on our behalf that affect us. Thirdly, the states generally implement international law through self-enforcement or voluntary submission to international mechanisms. And one major reason for this is reciprocity, or the fact that if one state follows the law, the others will also follow. And similarly, if this state doesn't follow, the others might not follow the law, and therefore cause detriment here. So it's a standard by which all states can follow a particular mechanism and improve, issues like trade or rights or a number of other factors. We can therefore say that at the international plane, a horizontal relationship exists between the states. And what we have to note is in the international system, only rarely are international legal obligations forced upon states by other states. And this is usually done through the UN Security Council, acting under Chapter 7 and taking action, for example, against Libya, or the UN Security Council acting against other countries where it has used force in Iraq or even Afghanistan, etc., like that. And it can do this through sanctions or through armed force, etc. Now we come to a situation where there's a lot of criticism at times placed on international law, and one of these criticisms is that international law isn't really a system of law, because powerful states can violate the law with impunity. They can violate the law whenever they want, and it doesn't really apply to them in the same sense. Another criticism is that there's no real enforcement mechanism. So you can have laws which, limit what types of weapons you can use or who you can target. But if a state violates it, how are you going to enforce that violation? How are you going to take them to court or hold them accountable? So these are two criticisms of law that take place. And that really begs the question, can international law still be called law if you can't really enforce it in the same way that you can enforce domestic law? But there's something important to note, that international law is overwhelmingly obeyed by most states most of the time. The reason for its seeming ineffectiveness is that the incidents of failure of international law, are often headline-making news, such as the genocide of Kurds, the Kashmir issue, Rwanda, Bosnia, the US invasion of Iraq, Israel's continued occupation of Palestine. These are things that come to our attention most often. But really, if we look at it, international law, the vast majority of international law is implemented like clockwork without us even knowing. So let me give you a few examples of international law in action, which maybe you don't even realize really affects your life. So the first is, for example, knowing what time and date it is anywhere in the world. We had a conference in 1884, the International Meridian Conference. A treaty was developed under that, and that created the time zones. So we know right now what time it will be anywhere around the world, simply by the location and the time zone it's in. Secondly, placing and receiving telephone calls across the world. That has been facilitated by international treaties such as the International Telecommunications Union that was created, the UN Space Treaty of 1967, and a number of other treaties as well. Flying shorter, more direct routes to international destinations. The fact that your plane from Pakistan can go all the way to the United States and cross dozens of countries without having to ask their permission is, creates a lot of ease for the airline industry, but also for passengers that are traveling across the world. And it's only possible because of these treaties and others as well. What about having access to your country's embassy if you're arrested abroad? If I, as a Pakistani, am arrested in, say, the United States, I have access to my embassy, and that is because of the Vienna Convention on Consular Relations. The software that I'm using, Zoom or Windows, or the Apple operating system, this is all possible because of the WIPO Copyright Treaty of 1996 and a number of other treaties that allow for intellectual property to be utilized and exploited across the world. The enforcement of arbitral awards without having a local court having to rehear the case. That is because of the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958. So we see a lot of this doesn't even come into our thinking. It doesn't come to our attention, but it's being followed like clockwork most of the time. So international law is functioning there. Now, let me just give you some further evidence of international law as a system of law. First of all, and this is perhaps the most important, states believe that international law exists. They act in accordance with international law. And that is why international law, we can say, is a system of law that functions. International law is practiced on a daily basis in foreign offices or ministries of external affairs or these entities around the world. Our foreign office has a legal department, has a legal advisor's office. It applies international law consistently. International organizations such as the UN or the World Trade Organization or the International Atomic Energy Agency, they all exist and function due to international law. They were created by international agreements. So we can't say that international law as a system doesn't exist. And perhaps most critically for lawyers in Pakistan or domestic systems, international law is discussed and applied in national courts. And we have a number of examples here before you. The Rikudik case, when it went even to the Supreme Court, they mentioned bilateral investment treaties, international arbitration that could take place. The Peshawar High Court judgment on drones, extradition cases that take place in domestic courts, they're based on treaties with other countries on extradition. The Kulbhushan Yadav case, for example, the court martial that took place, also factored in elements of international law. The Islamabad High Court case, which is actually implementing now the ICJ judgment on the Kulbhushan Yadav case. So international law is also being applied consistently in the domestic sphere. And one very important fact is that even where you don't have international law directly applying in a country, courts interpret domestic law in light of international law. What that means is that if there is a term which needs interpretation, courts can look at international law and see how it's been interpreted internationally and then apply that definition to a case before it domestically. So now that we've discussed that international law is a system of law, it might not, it's very different from domestic law, certainly, but it is a system of law, a unique system of law. Let's look at its sources. Where would we derive international law from? In a domestic system, finding out what the law of Pakistan is, I think the first step would be going to a constitution, going to the Constitution of 1973 and finding out what laws are created under that. That is your primary legal source. But after that, what you could also look at are a number of legislation, federal, provincial, that take place. Internationally, it's somewhat complicated, but still quite easy for our purposes, hopefully. So sources of international law, the best place to find out where we can find out what the entire body of international law is by looking at Article 38(1) of the Statute of the International Court of Justice. So the International Court of Justice is a body that applies international law and resolves international legal disputes, and therefore it required the sources to be identified. And it identifies a number of sources. The first is treaties. So treaties, conventions, all of the sort, that is the first source of international law. Secondly, at the same level, is customary international law. And I'll go into that in some detail right now. Customary international law is a nebulous concept, but it's something that's very important to know about international law. And it applies just as forcefully as treaty law does. So a treaty could be a text, custom could be ideas that have developed and accepted by states as legally binding. They both have the same level. At a subordinate level, you have judicial decisions. Now, one would assume that judicial decisions of, say, the ICJ should have the same level as the treaty or customary international law has. But we don't have the concept of binding precedent at the international level or for the ICJ. So even though previous judgments have persuasive value, they're not legally binding on, say, the International Court of Justice in the same sense that they are in, say, a Pakistani domestic court. Also at this subordinate level, you have academic writings. So writings of the most prominent scholars of international law. They can help as a source of international law for judicial decisions that are taking place. What you have after that are, and this is not mentioned in Article 38, but it's something that we need to understand now as international law is developing, is that international organizations can also create international law, not only for themselves. For example, they could come up with new rules for themselves, but they can also create binding law for states. One clear example of this is the UN Security Council. Especially after 9/11, it created certain resolutions that were essentially lawmaking resolutions. So you had, 1267, 1373. These were resolutions that placed legally binding obligations on states, all members of the UN, to not give any sort of protection to terrorists, to target terrorists, and to ensure that they're held accountable for their actions. There were also many monetary restrictions that were imposed on them as well. So these are the different sources that we have. Now let's go into this in more detail. I'm going to start off with customary international law, and then I'll go to treaties, and then we'll discuss the remaining several factors here. So the first is custom. Now the ICJ statute refers to custom as evidence of a general practice accepted as law. Now this seems like a very brief sentence, but it contains quite a bit in it. So A, there has to be a general practice. And secondly, this has to be accepted as law. So it's not just a habit that states get into. It is a general practice that these states feel is law as well, right? Even if it's not written down somewhere. Now, unlike treaties, which are only binding on their contracting parties, international custom is binding on all states. So a treaty, and we'll get into that in more detail, a treaty is only binding if you sign it and ratify it or accede to it, and then it becomes binding on you. But once a principle of customary international law is established and declared so by, say, the ICJ or accepted by states, it is then binding on all states, except those who have consistently objected, and we'll get to that, what a consistent objector is. So it's binding on all states there. And what is the formula for customary international law? One, there must be general practice or state practice, consistent state practice. And secondly, there must be opinio juris. And this is a funny, interesting concept where essentially states have to feel that they're legally bound by this legal practice, by this state practice that they're consistently doing. And we'll get into that in a little bit. So let's look at state practice. What are the elements? There has to be a certain level of duration. It should have taken place repetitively and consistently. So it has to be some duration. There has to be a level of uniformity and consistency in it. In essence, the same practice should have been done repeatedly. And thirdly, there has to be a generality. It has to be practiced by numerous states, or at least by the majority of states, or at least the majority of states who are especially affected by it. So for example, if we're talking about maritime law, it really doesn't matter what the practice of, say, landlocked states are. What matters is the practice of states that have, access to the sea. And so these are three elements which make the state practice element, which fulfill the state practice element. The second element is opinio juris. And this sentence tries to encapsulate what it means. Acting in a particular way because you think you are legally obligated to. That you don't just act, that state practice isn't just repetitive for out of habit or out of convenience, but because you are legally bound, because you feel you are legally bound by it. It's a subjective assessment that is taking place here, and sometimes difficult to ascertain. There's a very important case of the International Court of Justice, the North Sea Continental Shelf case, and I just want to read a very brief excerpt from it. Not only must the acts concerned be a settled practice, i.e. state practice, but they must also be carried out in such a way as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule requiring it, by the existence of a legal rule requiring it. The states concerned must feel that they are conforming to what amounts to a legal obligation. All right, and I'll give you some examples in a bit. The problem often is that opinio juris, how do we figure out what the beliefs of states are? I mean, it's difficult enough to find out what an individual's beliefs are, but what about a state? How do you know what the state's mindset essentially is? But what we can do is look at things that come out into the open, things that we can actually read and understand, evidence of this opinio juris. And that is things like official statements by the prime minister or the foreign minister, diplomatic correspondence, what have states said to other states, government press releases, speeches, say at the UN, submissions to tribunals, votes in the General Assembly, etc. That's where we would determine whether the state felt that the action, the state practice that it was engaged in, it felt legally bound by it. Now, once these two things come together, what do you have? You have customary international law. In essence, you have a consistent state practice by numerous states, all, or at least most of them, believing that they were bound, that they believed that they were legally bound to do so. Now, let me give you an example of this. We have the Vienna Convention on Diplomatic Relations of 1961. But diplomatic relations between states have gone on for hundreds and thousands of years, really, where the ambassador or the emissary of one state would go to another state, and he would be given special protections. For example, he could not be arrested. Criminal jurisdiction could not be extended upon this ambassador. And one major reason for this was, say, reciprocity. If I treat your ambassador well, you'll treat my ambassador well. If I protect the communication of your ambassador to his home state, you will do the same to me, right? But from this also emerged the legal obligation, where states felt that it would be a violation if we arrested the ambassador, where they felt that it would be legally wrong to, say, read his letters to his home state. That is where then customary international law developed. And in 1961, when the Vienna Convention came in, it only codified that existing customary international law. So the customary international law already existed, maybe for hundreds, if not thousands of years. And it was only in 1961 that we brought it together. So the law existed and states felt bound by it for a very long time. Now we come to the persistent objector. Now, as I mentioned, once customary international law is established, it's recognized, it is binding on all states across the world. The only exception to this is a state which can demonstrate that it has persistently objected from the time the custom was being developed. So it has persistently objected to it. It says that, no, we don't believe that this custom applies to us. That state then has, will not have the customary international law applicable to it. Now let's look at our next source of international law, and that is treaty law, essentially. Treaty law, if we look at the Vienna Convention on the Law of Treaties, this is a foundational instrument of international law. It helps interpret and understand international treaties, and something I would highly recommend that you go through. An international agreement concluded between states in written form and governed by international law. That is the definition. Whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. It doesn't matter what you call it. You could call it anything you want. Notes, for example, diplomatic notes. It could still be considered an international agreement. So treaties can be referred to by a number of different names: international conventions, international agreements, covenants, final acts, charters, MOUs, memorandums of understanding, protocols, pacts, accords, and constitutions for international organizations. All of these, it doesn't really matter. There's no legal change. A treaty is something that binds two entities. And once it's been brought into writing, that is when it becomes a treaty like that, and the intent to be legally bound by it, by the different states involved, is what makes it a treaty. So there are different types of treaties. One very basic type is a codifying treaty. Now, I just discussed the Vienna Convention on Diplomatic Relations. What did this treaty do? It took the existing customary international law, which wasn't really written down anywhere, but it was accepted and recognized as customary international law, and it brought it together into one treaty. And when you write it down, sometimes the understanding of customary international law can change. And the Vienna Convention brought all those rules together and may have even modified it somewhat. And now it is accepted. But what's interesting is, say, for example, today we were to eliminate all the countries in the world who have signed up to the Vienna Convention on Diplomatic Relations, said that we withdraw from it, we do not accept it anymore. And this convention dies. The customary international law will still remain of diplomatic relations. So the rules that were in the Vienna Convention will still apply because they predated the convention itself. The custom still existed. So that's an interesting type of international law, one that codifies, and brings into writing law that existed before. What we also have is lawmaking treaties, treaties which create new rules to be followed by those who ratify the treaty or accede to the treaty. Now, examples of this could be the treaty banning nuclear weapon tests, the NTBT, the Nuclear Test Ban Treaty, also say the UN Convention on the Laws of the Sea. But the UN Convention on the Laws of the Sea also has certain aspects of customary international law that were codified into it as well. So you can have a number of treaties that serve multiple purposes as well. Then you have constituent instruments or treaties essentially which create international organizations. So the Constituent Treaty for the European Union is the Treaty on the European Union. NATO has been created by the North Atlantic Treaty. And you have a number of these. The UN Charter creates the UN. And you can have a number of these treaties as well. And these treaties, interestingly, not only create the institution, but can also create obligations on states. So for example, the UN Charter not only creates the United Nations, but also imposes obligations on states. For example, Article 2.4, which says that there's a prohibition on the use of force. So states that accept the UN and help create it also must not use force now. They have to resolve their disputes through the UN mechanism or through other peaceful means. Now, an element which we see in Article 11 of the Vienna Convention on the Law of Treaties is consent. The consent of a state to be bound by a treaty may be expressed through a number of means. One is through signatures. Now, you must have heard that Pakistan has signed a treaty. Signing a treaty does not make you legally bound. It only imposes a good faith obligation to follow that treaty. So you're not legally bound. You can't be taken to, say, the ICJ for not following it. But there is a good faith obligation not to violate it, right? Then you can have an exchange of instruments. And if that is what, say, the treaty requires, that could make it legally binding upon, say, two states or something like that. There's also a ratification process that can take place. Now, essentially, your ambassador or your representative can sign a treaty, and then it has to be ratified, and different countries have different processes. In Pakistan, it is the federal cabinet that ratifies treaties. So if the federal cabinet, a treaty is brought before it, tabled, they agree to it, then it is ratified. And then they would take an instrument of ratification and submit it to the depository of the treaty. The depository can be the UN Secretary General. It could be, particular countries. But once you demonstrate that you are legally bound by it through the ratification process, you submit your instrument of ratification. And then you are formally legally bound by it, unlike the signature. Accession is another process where if a treaty has been developed before, say, a state came into place, or came into existence, or that state was not involved in the development of that treaty, subsequently a state can accede to it. It's the same as ratification, and the same process applies to it as well, and the same legal effects also apply. And there could be any other means which the parties agree upon, which could lead to the legally binding nature. So consent could be expressed through all these means. Now, there are two things. Once you've signed on to a document, you should remember that whenever treaties are made, they're done by all the states involved in the process. And there could be things that the majority of states agree upon, but you as a state are not comfortable with. That state doesn't want that. So it could impose or bring in a reservation to one particular part of this treaty. Now, what is a reservation? As per Article 2D of the Vienna Convention on the Law of Treaties, it defines it as a statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty, whereby it purports to exclude or to modify the legal effects of certain provisions of the treaty in their application to that state. So if, for example, Pakistan in the past had, there were a number of human rights treaties, and Pakistan had put in reservations saying that we will only accept these to the extent that they are in line with the injunctions of the Quran and Sunnah, right? So this was a reservation that we put in. You could also have declarations. Declarations, unlike reservations, don't want to modify the treaty. All they want to do is explain what the state's understanding or interpretation of that particular clause of a treaty is. So, for example, if Article 10 of a treaty is something that we feel has to be interpreted, Pakistan feels has to be interpreted in a particular way, we'll put in a declaration that way. And other states can then, object to or agree to that reservation at times as well. There are some limitations on the types of reservations that can be put in. Now, the first is, for example, there could be treaties that don't allow reservations at all. So the Rome Statute doesn't allow reservations at all within it. So if a country signed up to the ICC, the International Criminal Court, the statute of the International Criminal Court, it can't impose reservations. Secondly, there could be treaties which say that we will only allow reservations on certain parts of this treaty, on certain articles of this treaty, but not on others. That then, if you try to place a reservation on the other parts, that would be disallowed. And then finally, what you have is that you cannot bring in a reservation which is incompatible with the object and purpose of the treaty. In essence, the main elements of that treaty, you can't make a reservation accordingly. Because what that does is it defeats the purpose of the treaty. Why are you even signing it then? If it's not going to be, if the essence of that treaty is not going to be applicable to you. So these are three limits on the reservation of treaties. Moving forward, there is a requirement, a general requirement under international law that pacta sunt servanda. I'm sure many of you have heard this, that every treaty in force is binding upon the parties to it and must be performed by them in good faith. So abide by your promises, abide by your pacts, by your contracts, by your agreements. And we see this important case of 1997 by the ICJ. I'm not even going to try to pronounce this, but Article 26 combines two important elements. The later good faith implies that the purpose of the treaty and the intentions of the parties in concluding it, which should prevail over its literal application. The principle of good faith obliges the parties to apply it in a reasonable way and in such a manner that its purposes can be realized. So essentially, there is a good faith obligation for you to abide by your treaties, and that's what is the essence of these agreements at the international level. We also see that Article 27 looks at international law and observances. The party may not invoke the provisions of its internal law. So domestic law cannot be used at the international level to show that a particular treaty obligation does not apply to that state. You can't say that your domestic law supersedes that. And this is what the ICJ has also said in the Greco-Bulgarian communities case in the 1930s. This is the precursor to the ICJ, the Permanent Court of International Justice. It said that in case of a conflict between treaty law, international law, and domestic law, treaty law would prevail. And you can't use domestic law to override your international obligations, essentially. Now, how do we interpret treaties? The main tool, domestically, we have things like the General Clauses Act that help us interpret other laws and other acts of parliament. But under international law, the closest thing to a General Clauses Act that we have is the Vienna Convention on the Law of Treaties, much of which I was quoting previously. Similarly, Article 31 of the Vienna Convention on the Law of Treaties A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. And this is what we see. There's a multiplicity of factors involved in the interpretation. I would highly recommend that you read Article 31 of the Vienna Convention on the Law of Treaties, but it helps in understanding how essentially treaties are to be interpreted. Now, when can you invalidate or terminate a treaty? So there are a number of grounds. If it was done on error, in error, or if it was done on the basis of fraud, these could be grounds for the invalidity of a treaty. Some absolute grounds are coercion of a representative of a state. If a representative of a state is forced in any way, threatened in any way, coercion of a state by the threat or use of force. So the force, a threat of force that if you don't do this, we'll bomb you to the Stone Age. If you don't sign up to this treaty, that is enough grounds to get out of a treaty, an international agreement. Treaties conflicting with a peremptory norm of general international law. So you can't have a treaty that violates, a very high category of international law. So, for example, you can't have a treaty which says we allow torture in any way, because torture, the prohibition on torture, is a peremptory norm. It's just cogence. It's the highest form of international law, of customary international law, that is accepted by all states, and there's no reservation that can be made in that regard. Other forms of termination of a treaty, if there's a material breach by one party. A material breach is a fundamental breach, not a small breach, but a fundamental breach, much like contract law. If there's a material breach of the terms of a treaty, that is enough for termination. If there is a supervening or an interrupting impossibility of performance, some fundamental change of circumstance, these are also elements which would allow for treaties to be terminated. Now, another category which I didn't mention before, but certainly exists, is general principles of law. Now, these are principles of law which in one form or another is recognized in a wide range of national legal systems. So general principles applied in national legal systems could also be sources of international law. Some examples are laches, or good faith, res judicata, the impartiality of judges, or the concept of estoppel. These are all coming about and being recognized by, say, the International Court of Justice, but also a number of international tribunals as well. Now, why would we have general principles applying if we already have such a rich body of international law? There could be situations which arise when there is an absence of law relating to an issue. So perhaps there's not even a treaty on a particular issue, but it's come up before the International Court of Justice or some other legal mechanism. There's no method to legislate to provide rules to regulate new situations. And so general principles fill the gap so that we don't have a non-liquid, or we don't have a situation where the law doesn't apply or the law doesn't exist. Let's look at some subsidiary sources, some lower level sources than, say, treaty, custom, and general principles. The first is judicial decisions. These are a subsidiary source because there's no doctrine of binding precedent. And these could be based on ICJ judgments or even judgments of national courts. But it has to be noted that the ICJ does refer to a lot of its previous judgments in its case law. So even though it's not binding in nature, it's certainly persuasive in nature. The writing of publicists. Publicists, by this we mean, recognized scholars of international law. So the ICJ statute recognizes the teachings of the most highly qualified publicists of the various nations as a subsidiary means for the determination of rules of international law. The ICJ can consult and quote the writings of academic authorities when the need arises. Now let's move on. These are all the sources of international law, where we derive international law from. Now, who does international law apply to? We already discussed that primarily it applies to states, but the law has now developed. International law is consistently developing, and you have various international mechanisms such as the UN, as well as other international organizations that help international law develop. And they apply to different entities, and that is consistently growing. So what we can see over here is this simple slide. And firstly, it applies to states. So states like Pakistan, India, the US, South Africa, that's clear cut. What about international organizations? They're created by international law and so are necessarily bound by international law. So the UN, the European Union, NATO, SARC, all of these. But international law also applies to, say, multinational corporations, oil companies such as Shell, for example. In international investment law applies to corporations as well. In international environmental law has now obligations that would be applicable to say, oil mining or other sorts of extractive industries. And increasingly, these are applying to individuals as well. So you and I could be subjects to international law as well. For example, soldiers or commanders who commit war crimes, not only would their state be liable for their activity, but those individuals would be liable for violating the laws of war, which we refer to as international humanitarian law. There's law on piracy. So individual pirates, regardless of which country they belong to, they themselves could be liable under international law. People who are involved in slavery, we have international law that deals with slavers. And of course, human rights. Human rights apply to you and I. And international human rights treaties, therefore, allow us to have certain rights. And normally this is done through a variety of methods. And we'll go into that in a little detail in just a little bit. Now, as we mentioned, the primary entity which is governed by international law is a state. But then how do we define a state? Sometimes there's difficulties in that, especially if there's, for example, a civil war in a country, and multiple governments are set up, and they each claim to be the proper representative of the people. In such situations, you could have problems arise. But we have a criteria under international law for statehood, which would be a subject of international law. And this is found in the Montevideo Convention on the Rights and Duties of States of 1933, and requires that a state should possess a permanent population, secondly, a defined territory. So the territory of that state should be defined. Thirdly, there should be a government in place, and that seems rational. And from this element of a government existing, the state should also have the ability or the capacity to enter into international relations with other states. So be able to communicate and essentially have like a foreign office or a body that can deal with international states, and is also then bound by the international obligations that the international mechanism imposes. So these are the four requirements of a state. And there's a lot of debate that takes place based on this. For example, one element is that, you could have all of this criteria, but still not be recognized by other countries. So if we take the Taliban government before, the US invasion of Afghanistan, it was only recognized by, one or two countries. Pakistan, I believe the UAE, are the only countries that really recognize that government. But it's still, it met all the requirements of a permanent population, a defined territory, government, and a capacity to enter into relations with other states, but it was not recognized as such. So recognition could also be an element that you could attach here. Similarly, Palestine, for example, meets many of the requirements here. It is also recognized by about 137 states around the world, but it's still not a UN member state. And there are reasons for that. One is that to become a UN member state, you essentially need a vote by the UN Security Council, and there are vetoes that have, we all know that a veto can be used there and has been used to prevent Palestine from being recognized as a UN member state. But it is nonetheless given, observer status at the UN. Another important issue that I wanted to look at was the issue of sovereignty. And this is something that we need to understand in international law. So if we look at a state, it essentially has two types of legal obligations. The first is to its citizens. These are the obligations domestically. So what, say, the government of Pakistan or the state of Pakistan owes you and I. And thirdly, international obligations. So what the state owes the international community. Now, when a treaty is signed, these are obligations to the international community. But for example, if we take a human rights treaty, the human rights treaty says that you will give your citizens the right to life, the right to education, the right to free movement. But it's an international treaty. So essentially the state owes those duties to the international community, but they really apply to us. The only person who can benefit from this is me, you, the citizens of Pakistan. But how do we then get that to apply to us? So there is something known as transposing legislation or implementing legislation. And that is the mechanism where we take an international treaty or an international legal obligation, create a domestic law which takes and incorporates all those principles and then allows that to be used at the domestic level for our citizens. So for example, the International Covenant on Civil and Political Rights gives us enumerates a host of rights. So the right to life, education, etc., etc., etc. Freedom from torture. You have the UN Convention Against Torture. You have, right to a fair trial and due process in the ICCPR. A number of these rights. But how can I have those rights enforced as a Pakistani? My state may have signed it, it may have ratified it, but the only way I am going to have that is if there's a law in Pakistan which allows that to be enforced. So we have, say, the CRPC, we have the Constitution of Pakistan, the Criminal Procedure Code, which already gives us all of those, or a number of those rights. There could be some missing, but that is essentially domestic law. So if I go to court, I can't quote necessarily the International Covenant on Civil and Political Rights. If I go to a domestic court, the court will not listen to me that way. What it will listen to is, me referring to the Constitution of Pakistan, me referring to the Criminal Procedure Code, and the requirements of safe, fair trial and due process that are contained in both these documents, as well as a host of other, laws that exist in Pakistan. So this system where you have to create a special domestic law to apply the international law, that is known as a dualist system. And then there are monist systems which can directly apply international law into their legal systems, but there's no purely monist system. But countries like Chile, Mexico, the US even to an extent, are somewhat monist in nature, where their legal system automatically applies international law that is ratified by that state. Dualist countries, which are most Commonwealth countries, former colonies of the United Kingdom and Great Britain, so like Pakistan, we require implementing legislation, also known as transposing domestic legislation, which will then incorporate the international treaty into the domestic legal system. Now, just the last few slides, what I wanted to discuss very briefly was that there are major themes of international law that I think we should all be aware of. One is, for example, international human rights law. There are 9 core human rights conventions relating to the inherent rights of human beings, which are to be protected by and promoted by states. Which conventions am I referring to? You can look at these 9. So the International Convention on the Elimination of All Forms of Racial Discrimination, ICERD, the International Covenant on Civil and Political Rights, ICCPR, ICESR, CEDAW, the CAT Convention on Torture, Convention on the Rights of the Child, the International Convention on the Protection of the Rights of All Migrant Workers, International Convention for the Protection of All Persons from Enforced Disappearance, and the Convention on the Rights of Persons with Disabilities. Now, as you'll note in the brackets, some of these also have optional protocols. So, for example, the ICCPR has has 2 optional protocols. The Convention on the Rights of the Child also have optional protocols, which help expand what this convention is on. So, for example, some of the optional protocols for the Convention on the Rights of the Child deal with one deals with child pornography, one deals with children in armed conflict. And all of these help enhance the protections there. Now, Pakistan has signed most of these and ratified most of these, but not all of them. And it's always good for a state to sign up to these things and ensure that its legal mechanisms are then in line with these obligations. Another major theme of international law, and I'm sure many of you have heard of this, is the use of force. When can a state use force against another state? And once it uses this force, what are the rules of a war? What are the rules of using weapons and tactics? So this is governed also by international law. Firstly, you have jus ad bellum. When can a state use armed force against another state? When does it have the authority to attack another state? Essentially, there is no authority, because Article 2.4 of the UN Charter imposes a prohibition on the use of force. Yet we see warfare around us. We see, the attacks in Gaza most recently. We see a number of attacks happening here and there around the world. So there are some exceptions to the prohibition on the use of force. One is Article 51, which is on self-defense, which allows states who have been attacked to also then defend themselves. And this just makes normal sense. You and I, we also have a right of self-defense. It's contained in the Pakistan Penal Code from, I think, section 96 to 106 of Pakistan Penal Code. So if we can have it, obviously states should also have this right to defend themselves. The second exception to this prohibition on the use of force is when the UN Security Council authorizes states to use force, as they did in, say, Libya during the Gaddafi regime's final days. And they've done this in a number of places, in Iraq, in a number of countries, Yugoslavia, for example, back in the day. Now, once you've entered into a war, what are the rules on who you can target, who you can kill, what buildings or structures you can destroy? Those are governed by something known as jus in bello, or the rules of armed conflict. This is also known as international humanitarian law, the law of armed conflict, the law of war. And this imposes restrictions on the means and methods of warfare. Now, what do I mean by means? The means are usually the types of weapons I can use. So you must have heard that there is a prohibition on using white phosphorus in weapons because it causes unnecessary harm and unnecessary pain and suffering. Similarly, you can't use any form of chemical weapons in war. There's a chemical weapons convention. You can't use biological weapons. For example, a virus that you would create against the enemy. And what you also have to look at is then methods of warfare. So the tactics you use. Tactics could mean, for example, one particular tactic is no quarter, where you say, I'm going to go in to this particular area and I'm not going to take any prisoners. I'm going to kill everyone I see. That, as for a military commander, is illegal, unlawful. It's a war crime. If somebody surrenders, if somebody puts up a white flag, that necessitates them being accepted, their surrender being accepted, and they've been taken out of the fight because they have no military potential anymore. They can't damage you any longer. You have to make them a prisoner of war. You can detain them, you can put them in a prisoner of war camp, but you can't kill them. Then there are additional protections for civilians and civilian objects. You can only target military objects, and that's what international humanitarian law states. And then, there has to be prevention of unnecessary suffering. You can't unnecessarily create suffering for people. The aim of international humanitarian law is to allow states to fight wars, but to fight wars in as humane a method as possible, and to protect civilians and civilian objects as much as possible. So that is essentially, a very, very brief overview of international law. I'd like to thank you for taking the time, and I wish you the best of luck in your test. Thank you.
Thank you very much, Oves. I think that was amazing. Great. I'm one of the best presentations I have ever attended. So I really thank you for taking this session. And I must say that this is not the end, rather the beginning of our coordination and cooperation from this forum. So have a nice evening, and I look forward to working with you in future. Thank you very much.
Thank you very much.